Today, we are going to be diving into the important topic of probate in California when someone passes away without a will. Now, let's explore the ins and the outs of the process and what it means for the estate of the deceased. Hello, I'm Spade with Keller Williams Realty, where I make all these videos to help you make sense of the real estate market. If you would do me a huge favor and click that subscribe button and give me a like, I surely would appreciate it. Probate is a legal procedure by which a designated executor or administrator manages the assets of the estate of the deceased person. Now, this individual is also known as a personal representative. They are responsible for overseeing the estate's administration and distribution to beneficiaries and heirs. Now, in cases where a person hasn't left behind a will, the court is going to step in to decide how the estate will be distributed. The court first checks if the deceased had made any arrangements outside of a will, such as trusts, beneficiary designations, or joint tenancy deeds. Now, if no such arrangements ever existed, then the court is going to initiate formal probate proceedings. This is where we enter intestate succession. This is the process through which an estate determines who inherits the assets of someone who died without a will. Now, in California, this process is governed by the intestate succession laws, California Probate Code 6400 to 6455. Now, with intestate succession, the distribution of assets is automatically dictated solely by the law. These laws provide protection by ensuring that the closest family members of the deceased are entitled to inherit the property. So, who becomes the administrator of the estate in these cases? Generally, it's going to be a close relative of the deceased that is appointed by the court, provided they are willing to take on the role of the administrator. Now, the administrator holds responsibility similar to those of an executor, except that they must adhere to intestate succession laws. Now, they must follow instructions very, very carefully. Now, in most cases, the surviving spouse is given the first opportunity to serve as the administrator. However, if there is no surviving spouse or they decline the role, then the court is simply going to choose someone else. The California Probate Code 8461 outlines the hierarchy of who is eligible to serve as an administrator. But what if someone passes away without a will and has no known heirs? Now, in these instances, a public administrator may step in to handle the estate and search for potential heirs. If no heirs are found, the deceased property would eventually go to the state. Now, being an estate administrator is a significant responsibility that requires time and dedication, and if you are too busy or have conflicting commitments, it might be best to decline the appointment. Neglecting your duties could lead to claims of fiduciary misconduct. There you have it, the intricate process of probate in California when there is no will involved. Remember, proper estate planning can spare your loved ones from a lot of legal complexities. So if you found this video informative, be sure to give it a thumbs up and don't forget to subscribe for more. Also, I want to appreciate you for watching, but please remember, I am not an attorney and I'm not giving you legal advice, just giving you some things to think about as you're going through this process. Thanks for watching. Have a great day.